Good morning, everyone. I'm going to open the public hearing on HB 1614 in 1 second because I just realized that, oh, here he comes. So I will call up Representative Jess Edwards, who's asked for 4 minutes to introduce the bill.
For the record, I'm Representative Jess Edwards, representing Rockingham District 4, Auburn, Chester, and Sandown, here to introduce HB 1614 to the committee. I'm the chair of Division 3 Finance. We have financial jurisdiction over the Sununu Center. I was also appointed, along with your chairman, to the SYSC Replacement and Closure Committee, where we looked into things. In that committee, special committee, we went and visited the AG's office, and we spoke to the senior AG that handles civil procedure. So if we get sued, she gets the cases. And then if we need to prosecute somebody for poor behavior, the other senior AG was there. And so we didn't crosstalk because they have kind of a firewall between them. But as we talked about the kinds of things that they thought we needed to include in the replacement center, they both civil procedure and criminal pursuits were both very confident that they needed this bill, that there isn't enough storage of quality digital recordings, because as you can imagine, if we need to defend somebody, we want to have good video evidence and audio evidence, and then if you want to prosecute one of our employees or somebody else that's a visitor or guest, you'd still want the evidence. So if you had Mr. Goulet, the commissioner for DOIT here, and Mr. Wieters, who is the CIO for the Department of Health and Human Services, what they'd say is that they already do this. So you would get a little bit of conflicting testimony, and just to deconflict it a little bit, they currently are recording and storing for 2 years. And so we wrote on, where is it? On line 11, that the retention of the data should be a minimum length of time to make sure that justice is served. And in the financial analysis, they assume that that would be 7 years because there's a fiscal note with this. So in the fiscal note, you'll see $42,000 to build out the storage architecture to keep these images for a longer period of time. The reason we didn't put 7 years on line 11 is because federal and state law can change over time, and it may be appropriate to keep them 14 years or 20 years or whatever. So we didn't have to keep changing the laws. On line 10, 9 and 10, you'll see that the recordings have to capture the actions of one person and interactions between two or more people. We didn't specify what kind of people those are. Those could be guests of the facility. It could be our own employees. And so we had a lobbyist suggest to us that we specifically call out and say including law enforcement. And so if you hear that, I just want to tell you, I've thought about that. I just think that would be redundant because, you know, people are people. I think there's a 60s song about that. So we want them to maintain uptime of 98%, which is they don't currently have a standard, so this would establish standard. So, and with that, Madam Chair, thank you. I'll take questions if there are any.
Representative Grossman.
So be nice. My sisters are in the back room, so be gentle to me.
Thank you, Madam Chair. Thank you for coming, Representative Edwards, to present this bill to us. who can access the video? You may have said that, but who can access these videos?
This bill doesn't specifically refer to the access control. As I mentioned, they already have a system in place. The reliability and the length of time is really kind of the issue between the status quo and what we're proposing. So I didn't touch the access control issues because I believe it's already covered in the current system, and I do think that, you know, there is a reference here to requiring privacy pursuant to federal and state laws or regulations. That's related to the areas of control and not the access to the images. So it's not complete. I think if you wanted to amend this to be more specific, I wouldn't have any issue with that. But because I didn't pursue it, I don't know if it would be redundant with some other requirement that already exists.
Good, thank you.
Are there any further questions?
I have one further answer to give.
Sure.
There's a bill that I think has excellent prospects that will establish within the Department of Health and Human Services a security and IT governance committee who will be responsible for ensuring privacy. And they'll be doing it through establishment of various policies for IT security and privacy. And if the department doesn't already have a specific access control privacy to protect private access control policy to protect privacy, I'm sure that would be one of the things they'd do.
Representative Yokella?
Thank you, and thank you for taking the question. On that same line as the retaining a minimum length of time as justice may require, it talks about some provisions in the RSA which is relating to people being able to get this information so that they can put it in their court case. And is that the use of the recording in court cases is the main objective of this bill, and having that access so that they can have proof of what occurred in that situation, so that they can obtain justice from the judicial branch. Is that my correct understanding of the kind of thrust of this bill? Or
You know, I thank you for the question, Representative Yokella. I would say that depending on who you talk to, you'd get slightly different answers. When you say the primary purpose is for evidence for the court cases, you know, there's two types. There's the civil procedure where we get sued for damages. Then there's criminal in case somebody's violated a law. So in either court scenario, this evidence would be available and subject to discovery. I think another person could come in and say, no. The real reason that we do this is because when people know that they're being watched and there's evidence, they modify their behavior, and this is a prevention tool as much as it is evidentiary.
thank you.
Sure.
Are there any further questions? Oh, Representative Grossman?
Oh,
Or Representative Long? Which one had?
you called me. And I was
Representative
sharing
Grossman.
the
Okay.
microphone. Thank you, Madam Chair. So I had submitted a bill a few sessions ago for audio and video surveillance in group homes, and that there was a lot of privacy concerns. So in this bill, do you discuss placement? So where cameras, in terms of privacy of these kids, camera placement in terms of, like, we did common areas, but this is a different situation than a group home. This is a detention center. So was that discussed?
Thank you for the question. Okay, I would say that this, the video and audio recording in detention centers is an industry in itself where there are consultants that come in, and what this bill would require them to do, particularly in a replacement scenario where we build something new, is to do an architectural review of all of the angles to make sure that in the hallways and the kitchens and the dining rooms, you know, everywhere where people can, in the counseling rooms probably, they may want to turn off audio, but I don't know. But there will be, I'm sure, consultants that are brought in and do a mapping of the facility. That where you wouldn't put this is in those places that are protected by privacy law and federal, state and other regulations, like such as a bathroom. If somebody's using the facilities, you're just not going to record that. And there are probably other exemptions that are exempt. Does that answer your question? All right. Oh, and you mentioned group homes. If you look at line 4, it reads, each facility paid for in whole or in part with general funds and used by law enforcement, county sheriffs, or state police. So that certainly would include the Sununu Center, but it would not probably include group homes. So your bill is not redundant, it would be complementary.
Do you have any follow-ups? Okay, Representative Long?
Thank you, Madam Chair. Thank you, Representative, for taking my question. So back to line 4. So an out-of-state placement, a secure out-of-state placement, we would require videoing?
Thank you, Representative. My answer to that, and again, I'm not an attorney, is that this is New Hampshire law and would govern all facilities in New Hampshire. I think your question refers to whether or not we contract out support to out-of-state locations, and I don't think they'd be covered by this law, but this law might inform the contracting process where we would have to negotiate with Vermont or Maine or whatever. This would probably want to be a requirement, but this particular bill would not require our putting it into contract language. And so what I think you've done is I think you've discovered a possible hole that maybe an amendment could fill.
So follow up if I may. So your bill is New Hampshire only? Is
Yes,
what
sir.
You're looking for. Okay. And then the other follow up, if I may. It doesn't say who pays for the videoing. So, like, let's say the Nashua's Children Home, there's somebody being detained there. They're in New Hampshire. We're required for video. Who pays? Would the state be responsible for paying state facilities, putting the videos in? And the private entity we're contracted with would be responsible? That would be a requirement of the contract?
Okay, so there's a clear, bright line, I think, in this of what we pay for. What we wouldn't pay for is not in this bill. So the group homes, as I mentioned before, I think the group homes would be outside of this bill, and the other bill being presented by the representative could be complementary to this. But this is just general funds would have to be used to pay for the Sununu centers, for example. Okay. And anywhere, it also said, is anywhere where we want to securely detain minors. So I don't know that as a routine practice, the state securely detains minors at group homes. I don't think we do that.
Okay. Very good. Thank you.
Okay.
Are there any further questions? Representative DeSimone.
Thank you, Madam Chair, and thank you for taking my question. Considering some of the other questions, I'm trying to answer them in my own head. And on line 4, it says each facility paid for in whole or in part wouldn't that also therefore include if we outsource to another state and that facility has video cameras in it, wouldn't that protect the state of New Hampshire in allowing those facilities to use those cameras as we would? Since we pay those facilities to
Yeah,
take care of our youth.
thank you for the question. I think you guys are on to an excellent edge case scenario that I did not anticipate. I've always conceived this to be New Hampshire controlled facilities, but the way that sentence reads, and I'll be a weasel and say that I had OLS help me with the drafting. So I just didn't work through the scenario in my head when we contracted out. And maybe, I know Mr. Ribson representing DCYF is coming up, so maybe he could tell us what he thinks. I think it would be smart contracting to make it a requirement, but I'd like to take sort of another opportunity while I'm talking anyways, is I did not include body cameras. They haven't used body cameras. There wasn't a request for body cameras by the AG. And so it's silent on body cameras, and I don't know what this committee would want to do about that. I'd say take a baby step and just make sure we got the proper fixed recordings in place.
Okay, are there any further questions? All right, seeing none, thank you so much.
Thank you for your time.
And I'm going to ask Director Ribson to come up and maybe address some of these questions that were put forth, if no one objects.
There we go. Good morning, members of the committee. Joe Ribson, Director, DCYF. Thank you for hearing me today. Good to see everybody this morning. Yes, we didn't officially take a position on this bill. I'm here primarily just to provide information, but I heard some questions brought up last time that might be helpful for me to provide some information on. So a couple things. Currently, SYSC is the only facility in the entire state of New Hampshire or anywhere in the country that takes detained and committed kids from New Hampshire. There are no detained and committed kids in private facilities. There are no detained and committed kids in other states. There are kids who are in residential programs for other purposes, but they've not been detained or committed by the court, or they've been maybe released on parole or what's called administratively released. That's when we determine that a child's needs are best suited in a residential program rather than in SYSC. So the questions about this applying to other settings really don't apply to today's state. Of course, there's conversations around the future of detention and commitment in New Hampshire, and should that future look different, that answer would be different. Two, in terms of what we already record, about 2.5 years ago when we started hearing about this litigation coming forward, we took a look at the existing video surveillance system within SYSC and found that it wasn't up to where we wanted it to be. The quality was low, the camera placement was not capturing everything we wanted to capture, and the department made a significant investment in putting in a new, very high quality camera system which captures everything in the building, everything on the perimeter of the building, except for most bedrooms, and I say most because there are a couple that have cameras for when a young person is on a suicide watch so that we can watch that, and that is allowable under federal and state law, and bathrooms. Most of the bathrooms in SYC are single-use bathrooms, single-use showers. If a child is on something like, in those instances, if a child's on some type of watch status where we're worried about them trying to harm themselves, the staff actually will go in with them, which I know is not a comfortable thought, but we have to make sure that we're safe for kids. But we don't record inside of there. So I think those are the basic two questions that came up. I'm happy to answer others if people have, or go further if folks have follow-up.
Representative DeSimone, and then
Thank you, Madam
Representative
Chair,
Long.
and thank you for taking this question. Can you talk a little bit about storage?
Yeah, so currently, the video storage, so currently I think it's around 2 years worth of storage, but actually up until months ago, when a litigation hold was put into place, it wasn't even kept for that long. It was only kept if there was an incident, and then it would be held. Now, the problem with a standard like that is that sometimes somebody brings up an allegation later than we realize, and then that video would have been gone. So at this point, at this exact moment, because there's a litigation hold, nothing is being destroyed or eliminated. But I do think changing to a system where it's held, I think the reason the department assumed 7 years was because that's, I believe, the statute of limitations. Moving to a point where you hold this video for a longer period of time, I think makes a lot of sense.
Representative Long?
Thank you, Madam Chair. Thank you, Mr. Ribson. Okay, with respect to detained and committed, there's no scenario with respect to a mental health facility or a substance use facility where somebody would be detained or committed?
Not for the purpose of detention and commitment, no. If the court
Okay.
orders detention and commitment, that's a separate standard, and the only place where they would go is SYSC right now. Lots of kids go to programs like that, but that's based on treatment needs and based on an identified, need to have a child reside in some place to have their, their needs met.
Okay, so, follow up on me. Do you think that that should be specified in the bill?
It's clear to me, as the person who does this, the way
Yeah.
that it's written, because it talks about applying to facilities for detention and commitment, which to me reads it's only SYSC today, but it leaves room that if in a future state some other facility is identified for detention and commitment, that this would apply to that facility. So I think for my purposes it makes sense, but I can understand people who don't have the same exposure to this work that I do on a day-to-day basis might not follow that the same way.
Okay. And then, a follow-up if I may. With respect to out of state, are you in agreement that we should just concentrate on the state of New Hampshire right now?
I think, given that the only facility that's used is in the state of New Hampshire, I think that's the right place to put our
Okay.
focus. During the committee process around the replacement and closure of SYSC, there was a lot of discussion around the importance of making sure that kids stay as local as possible to their communities, because when kids go to SYSC, it's very infrequent that they're there for very long. They're going to reintegrate with their families, they're going to reintegrate with their communities, and having long distances makes that harder.
Okay, great. Thank you.
Representative DeSimone?
Thank you, Madam Chair. As a follow-up to my prior question concerning storage, do you feel that it would be necessary for your department to specify in the law the 7 years?
I don't think so. I think the way that we read it was that it's as necessary for litigation, criminal justice, all those types of purposes. I don't remember the exact language in here, but that's how we read it, and that's how we got to the 7 years. So if at some point the statute of limitation changed or something like that, we would be able to change the time period that the records would be retained.
Thank you very much.
Okay, are there any further questions? All right, seeing none. Thank you so much for the information.
Thank you.
Okay, so I'm going to close the public hearing on HB 1614, and we'll be back at 10:30 for 1612. Okay, so I'm going to open the public hearing on 1612, and I will call up Rep. James Spillane, who's asked to speak for 10 minutes.
Thank you, Madam Chair and members of the committee. I bring forward HB 1612 FN as an attempt to stop the abuse of the system, allow limited and crucial DCYF resources to be invested in true cases where children are in danger, and to allow the state to apply penalties to those who make malicious and intentional false complaints. I do not know if the system has become more weaponized and abused lately, or if I have only come to notice it through my constituents. But what I once thought was an occasional false complaint made with knowingly malicious intent has become more commonplace. I'm sorry to say I hear it most often with regards to divorces, where one party is having friends, love interests, or family make anonymous complaints against the other party to gain some perceived advantage in court regarding custody. I know of one person right now who's been in the divorce process for 3 years with 4 young children, and who has had 6 separate complaints filed by the new love interest of their former partner. It's for that reason that I include the ability for the court to appoint a guardian ad litem to be able to recognize a pattern of malicious and abusive complaints being made in any situation where there's custody involved, a divorce situation. The bill does not remove the protections, and I repeat, does not remove the protections that are afforded to those making a complaint in any way. It changes the concept of anonymous reports to one of confidential reports. To any of you who have friends or relatives in the police force, you'll recognize that the protections afforded to confidential informants is extremely strong. The rest of you probably recognize the protections afforded to juvenile records. Protections in this case are just as strong, as it would take an absolute proof of malicious and harmful intent to unmask any identity of anyone who makes a complaint. For that reason, I don't think that this bill would ever affect a first-time complainer. It would have to show a pattern of false complaints before that person becomes unmasked to try to find out who's making the false complaints. As such, this bill will mainly target those repeat abusers of the system, where the pattern of definitive malicious and harmful intent can be proven. Finally, the bill provides for penalties after someone has been proven to have made malicious and deliberately harmful complaints. I have a handout from the United States Bureau, the Children's Bureau, which is located at childwelfare.gov, and it shows the landscape across all 50 states and Puerto Rico for both failing to report and for falsely reporting. 29 states and Puerto Rico all have penalties in place in varying forms and amounts to address false reports. New Hampshire has none. The closest we have in New Hampshire is filing a false police report, but a report made directly to DCYF is not technically a filed police report, so court action is doubtful. The state would not be able to reach the burden of proof on that it was a filed false police report, and there's no law saying they can't make a false report to DCYF. In addition, when complaints may be taken completely anonymously, there's no way to identify a repeated abuser, even should a pattern be recognized. And every time a false report is made, even when there's a pattern of false reports, DCYF has no other option but to fully investigate the report. That takes valuable resources away from other cases, and we end up with situations like we have with missing child Harmony Montgomery. I will give you the handout that I have to the secretary so you can all get copies. I didn't have time to make copies for everyone this morning, and it's a pretty thick report. But I ask you to support HB 1612 FN and to help deter malicious and harmful false reports in New Hampshire while allowing DCYF to focus their very crucial resources on the cases where children are in actual danger and not being used as collateral pawns by selfish adults. And with that, I'll take questions if you have them.
Are there any questions? So I have one.
Yes, ma'am.
So who pays for the GAL if the parents can't afford to pay for the GAL?
Well, if the parents can't afford it, I think if you're aware with the court, they usually assign the cost of the GAL to one parent or the other based on whoever's more financially able to do it, or sometimes they split it. If neither parent was able to pay for it and The court, again, it's an option. The court can appoint it. It's not saying the court must appoint it. So the judge, in his wisdom, would be able to decide, in my opinion, whether one's necessary. And if one was necessary for the protection of one parent, one would hope that that parent found a means to pay for the GAL. And if not, I imagine it would probably fall on the state.
Are you aware that in the bill it says shall, not may?
It was supposed to be a may, and I missed that.
Are there any further questions? Representative Long.
Thank you, Madam Chair. Thank you, Representative. Now, these reports just refer to neglect and abuse.
Yes, sir.
Okay, so, and a follow-up, if I may? So, with respect to a CASA or appointment, that's at no cost, correct?
I imagine that's, I believe that CASAs are no cost.
Right, okay. And is there, follow-up, if I may?
Certainly.
Is there a point where it becomes, we start to realize that it's being malicious? I mean, is it 2 times? Is it 3 times? Is it 4 times?
I think that the experts at DCYF would be able to recognize the pattern better than I would. I can definitely say that 6 times, I think you've already established a pattern when they've had to investigate 6 times to find nothing, and they're still getting calls. Sometimes it might be 2 times. I doubt that any first-time call would ever establish a pattern. It's 1 time.
And
Follow
one
up.
last one, if I may. Thank you. And this is not only for parties involved. This could be a mother-in-law or a grandfather or.
I have seen this weaponized against political officials when somebody didn't like what they were doing. I've even heard of it being used by a neighbor who was disgruntled about the way that their neighbors were behaving and made a call into DCYF anonymously.
Okay.
It's being weaponized more and more, I think. But as I said in my testimony, I don't know if that pattern always existed and I'm just noticing it more, or if it's become an aspect of social media and the spread of people deciding that they can try to get the other person by using the state against them.
Very good. Thank you.
Are there any further questions? Representative Yokela.
Thank you. Thank you for taking the question. It seems to me that this is really 2 different subjects, I guess. One of them is in divorce proceedings, you should have a guardian ad litem, and the other one is if you're making false reports, there should be something that a rule that you're breaking. Is there a connection that I'm missing between the 2, or is one of them, if let's say, for example, we did not agree that you should always have to have a guardian ad litem, could we still keep the bill having punishments for making false reports to DCYF and it still stand on its own, kind of a thing?
I see where your question's going, and yes, it does stand on its own. I only added the guardian ad litem as a disconnected third party to recognize the pattern of abuse. And if that was something that because the guardian ad litem, if you're in a divorce situation, which is where I think it happens most often, my thought and the answers I got from some people that I talked to was that the guardian ad litem, if the court decided to appoint one, would be able to see, having known the children and interviewed them, that these reports had a false malicious intent to them, and be able to add on a sooner not rather than waiting for 6 complaints, they'd be able to see after the second one or the third one that this is bogus, and be able to say we need to put a stop to these false complaints and get on with the case in court for the divorce. So it's related via the false complaint being made. And as I said, only one part of it is the divorce situation where the complaints are made. There are a lot of reports made outside of a divorce situation.
All set?
Yeah. No.
No follow-up?
Yeah. So, thank you for taking this follow-up. It seems to me that the language regarding guardian ad litems is only in divorce proceedings. It specifically states
Correct.
that divorce proceedings, and it would be in cases that are brought pursuant to this chapter. So, in my reading of it, the DCYF would have to make a judgment on whether or not something was malicious, and then they would recommend that charges be filed, and then when the charges were filed, the case would exist. Before that, the case doesn't really exist, and then the GAL would do the research for the court to find out whether or not this
Yes,
plausible?
if the complaints are made and there's currently a coexisting situation for custody, which could be inside or outside of a divorce proceeding, but if there's children involved in a custody situation and the complaints are being made to try to influence that, then the GAL could, once the determination was made by DCYF that there was a pattern of abuse here, and they want to unmask the person and have the GAL look at it, they could have the GAL look into it before they decide to unmask the person and decide who's actually making those anonymous complaints. The GAL could look into it and see, is this truly malicious? Are the children being harmed more by the complaints than the situation that they're living in? Because children are harmed by the false complaints.
Are you all set?
Yes, thank you.
Are there any further questions? All right, seeing none, thank you very much.
Thank you.
Up next is Director Ribson from DCYF to speak in opposition to the bill.
Good morning, members of the committee. Joe Ribson, Director, DCYF. Thank you for hearing my testimony this morning in opposition to this bill as drafted. I do appreciate the issue that the sponsor brought forward as being one that is worthy of the state thinking about. We do see situations where people attempt to weaponize the child protection system in private custodial matters. Sometimes they're divorces, sometimes they're not divorces, but we do see it happen. We also do see situations where we believe people are making complaints that are unwarranted, but nevertheless trigger an investigation, because for us, if we get an allegation that, if proven true, would be abuse or neglect, we must screen it in, we must investigate. Which means some people who know how to craft allegations could make false allegations and trigger an investigation, even if it's something that's not warranted. And we would think it would be somewhat of a dangerous position for us not to follow up on something like that. So I understand the intent of this, and I think this is actually a space where folks could come to some solutions to try to improve that aspect of the system. It does waste resources, it has folks digging into problems that aren't really problems, and it is bad for kids and families to have them scared of the child protection system unnecessarily all the time. At the same time, my biggest concern with this bill is the elimination of anonymous reporting. While I understand the intent here is to make sure that people aren't making false reports and to be able to identify who are making repeated reports, we often get anonymous reports that are warranted, that are founded. And while I would prefer, and we ask everybody who calls to identify themselves and tell them that we'll keep their name confidential unless told by a court that we have to share it, and that does happen sometimes, a lot of people still choose to report anonymously. And I can't imagine a situation where we get a call. You know, some of these are pretty horrific calls, right? Somebody's a victim of domestic violence, there's something horrible happening to their child, they're afraid to identify themselves, and I can't imagine getting that call and the caller, the screener on our side saying, sorry, you won't tell me your name, so we're not going to go out and look at this. It's not something that I think is good for kids. I think we have to come up with ways to address that issue without completely eliminating anonymous reporting. In terms of the first part, right, the part around the appointment of a GAL, I think there's lots of practical implications that the committee's tapped onto that need to be figured out. I don't think it's a bad idea having an independent person look in custodial disputes and divorces, especially where it looks like the child protection system is being weaponized. But figuring out how to do that is complicated. Who's going to pay for it? I would say I'd want to be very careful that DCYF doesn't get put into the role of becoming that expert for those cases. Our role is abuse or neglect. We have to focus on abuse or neglect. And when you get into the realm of talking about best interest of kids and weighing parental rights between two people who are legally fit to be parents, that's not really DCYF's role. And then finally, the last section of this around the potential for false reporting and making that a misdemeanor. There are many states in the country that do that already. I don't have a particular objection to it. I would just say something for the committee to consider is, potential chilling effect. How do we message that? How do we talk about that to make sure that folks understand that making a good faith report is absolutely a protected activity, and it's only if you're intentionally trying to weaponize the child protection system that you'd be at risk. And with that, I'm happy to take questions.
Okay, so I have a quick question. Because it does state in here that CASA would be, but I thought CASA didn't do parenting cases like that. I thought
Correct.
they were strictly for a child that is in an abuse or neglect case with DCYF, not, and they don't do family court as far as divorces or custody, whatever.
Yep, that's absolutely right. They only take on cases of child abuse and neglect. That's under, their own structure, their own statute. They are mostly volunteers. They receive some money through the courts, and they receive some money through us for training, but it's overwhelmingly volunteers that do that work. And I don't think they would see this as being part of their mandate and mission. I think I'm not sure the way that it's written actually says it has to be a CASA. It says a GAL, and there are GALs that are not CASAs, but I do think that's something that should be clarified.
Okay. Representative Yokella.
Thank you, and thank you for taking the question. In these states that have punishments for knowingly trying to weaponize DCYF, are those, do those states allow, or do you know if those states allow for anonymous reporting? And if they do, is there a way, like, recordings of the phone call and the phone number which the police could then use to demask someone if it was found that they were in violation of the crime?
Good question. I'm not sure what happens in most of those states. As you heard, it's actually a majority of states that do have some statute on the books around that. I can tell you one of the big differences between the state where I previously worked and that I currently worked is that in New Jersey, we did record all the calls to intake. In New Hampshire, we do not do that. That is a way of being able to identify folks, even if you're taking anonymous calls and establish patterns. That's not something that I would be opposed to, but there would obviously be fiscal and practical implications around establishing that here because we don't currently record calls to intake.
Are there any further questions for the director? Representative Long.
Thank you, Madam Chair. Thank you, Director Ribson. In your experience, have you identified reports that were malicious or false?
We've seen, it doesn't happen all the time that it would cross that threshold. It's pretty infrequent, but we have seen them. And actually, the times that I see them, oftentimes are the same cases that I'm hearing from your colleagues on, right? One of your colleagues is hearing from a constituent who's unhappy that they don't think DCYF is doing the right thing. We get a call from one of your colleagues, take a look at this, and we never share the information with your colleagues because it's confidential, but we meet with those folks. And oftentimes, it's these custodial disputes where there might be a difference of opinion between what's the best thing to do for a child or the best way to raise a child, but that's not abuse or neglect. And I think part of that comes down to this, I think there's a misperception of what DCYF's role is in this state, right? That folks have an opinion that we're supposed to be out there kind of policing all parenting interactions and deciding what's best for all kids, and that's not our role. Our role is very limited to abuse and neglect, which is a pretty high standard, and parents have a lot of leeway to determine what's the best way to raise a child. And when you have two parents who are separated, you'll often have two parents who have different ideas about the best way to raise a child. And that's the line that I try to be very careful of us not creeping into, because we're not authorized to do that, and we're also not resourced and built to do that.
Right. Okay, follow up.
Follow up.
With respect to anonymous reporting, in your professional experience, would you suspect that there would be a decrease in reporting if I had to give my name, address, phone number?
Yeah, there probably would be. There'd probably be some folks who would not be comfortable making a report if they were not allowed to make it anonymously. And I'd be worried about what we might miss in those circumstances. Sometimes those reports are reports where there's some really bad stuff happening.
Sure. Very good. Thank you.
And just to follow up on that, I think that people are fearful, right? A domestic violence case, for instance, if someone is actually still in the home and able to get out, I think that would that not create a larger problem?
I think that's probably the number one scenario that I think about where anonymous reporting is appropriately used. I'll tell you, so there are situations where I think it's inappropriate. I personally think that professional reporters should always give their names. Our law doesn't require that, but we try to educate folks. We have good colleagues through the Know and Tell process, which is our child advocacy centers. Granite State Children's Alliance run that, where they really encourage folks to identify themselves and talk to them about the confidential process. But in almost all instances, you want to know who the reporter is because you want to be able to follow up and dig deeper. And the phone call that somebody receives at intake is not going to be as deep as a follow-up conversation with an investigator who's been able to look at other facts and circumstances and follow up. So we really do want people to use their names. I would just be afraid to say that we'll
Have
never
to.
accept a report where somebody doesn't identify themselves.
Are there any further questions? All right, seeing none, thank you very much.
Thank you.
Up next is Richard Head. He's asked for 2 minutes to speak to an amendment request.
Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I did submit written testimony on the online submission process. It's a fairly simple request dealing with the effective date of 60 days. We're asking that it be moved to January 1, 2023. And the reason being a statute that governs effective dates of legislation, RSA 14:9-A, provides that every law affecting judicial practice and procedure or establishing or eliminating criminal prohibitions shall take effect on the January 1 following passage. This bill creates a new RSA 169C31 Roman paragraph 2, which creates a new criminal penalty. And the reason we care is there's a process after the legislative session dealing with a whole host of changes to legislation. If you look at it just at the criminal provisions, there's the J1 program where we have the uniform charge table, where every criminal charge is listed on a table. That is used by law enforcement when they are charging individuals to make sure that we have consistency, and then it ties into the Odyssey database that the court maintains. And anytime there's even a minor tweak to any line in the criminal code or any statute that has a criminal provision, the uniform charge table has to be modified and updated, and our Odyssey database has to be modified to match it exactly. And over the course of a legislative session, there's several hundred at least changes that are made, and it just takes a great deal of time to make sure it gets done. It's done with the Department of Safety, Department of Justice, and our office, and trying to make sure that everyone is exactly right, because it affects how charges are made. So we simply ask that there be an amendment to change Section 5 of the bill effective date to 60 days after passage. And then with regard, and just since there was a question about the GAL, it does say shall appoint. There is not a GAL fund, so there is no state fund currently. There previously had been. It is no longer in existence, so there is no state fund that does pay for GALs when the parties are unable to pay. And with that, I'd be happy to answer any questions.
So I just have one question. So then even if we changed it to May, would that then leave some at some cases at almost an unfair advantage, or, right? So, I mean, just because you're poor doesn't mean that, you shouldn't have a GAL in that case, right? So, but if we're only going to allow those who have the money to pay, I just feel like there's a big kind of conflict there where we're leaving a bunch of people out if we're.
The GAL fund was useful.
Yeah.
Currently, if the parties are unable to pay, that is a consideration the court takes into account when appointing a GAL, and if the parties are unable to pay, there is no other funding source. So there are certainly cases in which a GAL may be appropriate that do not get appointed a GAL. I won't disagree with that.
Okay. Thank you very much.
Thank you very much.
Up next is Will Estrada from parentalrights.org out of, is it Louisville, Virginia? Lovettsville, Virginia, to speak for 5 minutes in support of the bill.
Good morning, Madam Chair, members of the New Hampshire House of Representatives Children and Family Law Committee. My name is Will Estrada. I am an attorney, a husband, a dad, and the president of parentalrights.org. We're a nationwide nonprofit that has advocated for protecting children by empowering parents for the last 15 years. I want to speak today about why Representative Spillane's bill, HB 1612, is so important. This bill will replace anonymous reporting to DCYF's hotline with confidential reporting. Anonymous reporting refers to the ability of a caller to make an allegation of abuse or neglect and not leave any identifying information. With confidential reporting, DCYF still keeps the caller's identity a secret, but the caller must provide the name and other identifying information. And importantly, the bill states, quote, "The department shall inform the complainant that should the complaint be made maliciously or with intent to harm, that the identity of the complainer shall not be kept sealed," end quote. And the bill provides civil and criminal penalties if a caller, quote, "knowingly make false statements of suspected child abuse," end quote. HB 1612 will significantly reduce, if not eliminate, false and malicious reports of child abuse and neglect, thereby protecting innocent children and families and allowing DCYF to focus attention on children who are truly victims of abuse and neglect. What is the cost of an unnecessary government investigation? The director of DCYF alluded to this, and I want to direct you to a law review article by Doreen Lambelet-Coleman entitled "Storming the Castle to Save the Children, The Ironic Costs of a Child Welfare Exception to the Fourth Amendment." This was published in the William and Mary Law Review in 2005. She wrote the following, quote, "In the name of saving children from the harm that their parents and guardians are thought to pose, states ultimately cause more harm to many more children than they ever help. In 2002, for example, the states conducted approximately 1.8 million investigations concerning the welfare of nearly 3.2 million children. Only about 896,000, or 28% of these children, were ultimately found to be victims of abuse or neglect. 71%, or roughly 2.3 million children, were thus subjected to state-mandated, thorough investigations involving at a minimum interviews, examinations, and/or home visits in circumstances where the state, in the end, could not show that the children were unsafe and in need of rescue. Investigating these children is consistent with the state's highly precautionary strategy to remedy the nation's maltreatment problem. However, from the perspective of the investigated child, the process is not so clearly meritorious. Indeed, despite the authorities' best intentions, the process can be harmful in two related ways. First, the investigations undermine the fundamental values of privacy, dignity, personal security, and mobility that are protected by the Fourth Amendment. And it's critical that, in this regard, that the Fourth Amendment uniquely has been interpreted to recognize the child's own individual interest in these values by guarding her right also to be free from unreasonable searches and seizures, both inside and outside the family home. Second, depending upon the child and the nature of the investigation, the process can cause severe emotional and psychological damage ranging from temporary discomfort to significant long-term harm," end quote. This account is nearly 20 years old. Today, based on national numbers reported by the states and published through the U.S. Department of Health and Human Services Administration for Children and Families Children's Bureau, the figure has held steady in recent years at around 83% of child abuse and neglect investigations are unfounded. And shockingly, among investigations started with an anonymous tip, the number of false or erroneous reports jumps to a whopping 96%. The reason for this is simple. If you and I were to suspect child abuse or neglect was going on, we would have no hesitation to provide our name or contact information. We would do anything to protect a child. But when you bring in anonymous reporting, there is no such protection. Anonymous reporting encourages false reports by disgruntled neighbors, political opponents, scorned lovers, and ex-spouses. There's a term for this that we've heard: weaponizing the system. HB 1612 will end this loophole in the law. It will end the system from being able to be weaponized against innocent families. Importantly, also, there's an equity issue. It will protect families of color, as studies have shown through the federal government and others that children of color are removed from their families at far higher rates than white children. Passage of HB 1612 into law will protect innocent children and families, and it will allow DCYF to focus on children who are truly at risk for abuse and neglect. Thank you.
Are there any questions for Mr. Estrada, Representative Yokela?
Thank you, and thank you for taking the question. I'm going to kind of re-ask the question that I asked before about other states and how those other states, if you're aware, have punishments for people trying to weaponize the DCYF system, and if those states are all require confidential, or do some allow anonymous reporting, and then if it is found to be malicious, then DCYF could hand over the phone number and a tape recording of it to the police, and the police can do an investigation to see if that if they can identify that person and charge them.
I would refer you to a law review article by Dale Checka. Her name is spelled C-E-C-K-A, and I can provide you later at that. It's 64 Catholic University Law Review 51, published in 2015. Dale Checka was then a professor of law at the University of Richmond. She's now the Assistant Attorney General for the state of Georgia. And she went case by case through every state. 40 states in the District of Columbia allow by statute anonymous calls to their child abuse hotlines. There are 10 states that have confidential reporting. All these 10 states, however, do have procedures in place where they'll encourage confidential reporting. So give us your name and phone number, but if the caller refuses to, they won't push it and they'll still accept the report. All 50 states do have state laws that make it a misdemeanor to make a false report. The difficulty, however, is if you're accepting an anonymous report, it's difficult to prove it. I think we heard from the or difficult to find who made that report. We heard from the head of DCYF that New Jersey, for example, records these calls. No one's really spending the time to do voice analysis or find that out. So again, it's very, very difficult to find, if you're accepting anonymous reports, who actually is making those anonymous reports if they're false. Does that answer the question?
Follow up?
Yeah. Can you, I guess, just, it sounds like not all of the states that have, from your testimony, it sounds like not all the states that have misdemeanor punishment require confidential reporting. Some do still allow anonymous reporting, even though they have that punishment. Is that
Correct.
Your testimony? Am I understanding that correctly?
Correct. Yes.
you.
So again, 40 states allow in their code anonymous reporting. 10 states will encourage the confidential reporting. It's in their state code, but the state children and welfare CPS will still accept these confidential reports. Although they have the misdemeanor charges for a false report, it's very difficult to actually prosecute those because there is just no information that's provided.
Thank you.
Are there any further questions? Representative Long?
Thank you, Madam Chair. Thank you for taking my question. Thank you for your testimony. So, is your testimony that there are no states that require your name when reporting? Some
There-
encourage and some absolutely don't.
Great question, Representative. So 10 states do require it in their state reporting. And again, this was Dale Checka's analysis state by state. But of those 10 states that have a confidential reporting statute as opposed to anonymous, they still, by policy, will accept an anonymous report. It does provide greater protection, though, and I think one of the benefits of HB 1612 is just that fact that the DCYF person who's answering the phone on the 24/7 anonymous tip hotline or hotline will give that warning that if you file a false report, you could face penalties. That's something that would be unique in state codes, and I think would be very helpful in reminding people this is not just something. This is something. If you're filing a false report, it can come back to bite you.
To follow up, if I may.
Follow up.
Thank you. So would this be if this were to go through, would this state be the first that does not allow anonymous?
It would join the other 10 states that by statute don't accept anonymous. I guess it would depend on how DCYF would implement it. The way it's written, it doesn't, in my mind, prohibit DCYF from still encouraging the confidential reporting. So there may still be an avenue where they would take down that allegation. I don't see it prohibiting that. But it would, so it wouldn't make New Hampshire alone in that case. It would become the 11th state. I think it would significantly reduce the concerns of that we've raised of anonymous reporting.
Very good. Thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you, Madam
Up
Chair.
next is it Ribson? Chester, to speak in support of the bill. I'm going to ask you to keep it to 3 minutes because we're really running short on time.
No problem. Hi, my name is Roseanne Chester. I wanted to come forward as a former CPS worker here in this state as well as in another state. My experience in this state, although it's older now, as a worker, we have always wanted to know the name just in case. So, and I understand the whole issue with anonymous reporting, and we don't want to do any kind of chilling effect. I understand that completely. There's an easy fix to that. We have an 800 number that goes to central intake. That central intake can take that information and keep it, and if they don't want their information disclosed, they put a star on it or something so it doesn't go to the district office, so the person that's doing the investigation doesn't know what's going on. But if we need more information, because to be honest with you, we're a small state. By the time we get out there, parents usually know we're coming. If they're trying to hide something, they can. I can honestly tell you, I think a lot of our devastating results of child illness or child abuse and neglect in the state is because of anonymous reporting. We are one of the few states that allows every adult in this state is a mandated reporter. That being said, with that kind of responsibility, with that kind of responsibility comes some sort of accountability. So what happens when an anonymous report comes in, the person goes out. Sometimes if you get a ton of anonymous reports from the same, you get it on the same family, those end up getting screened out. And then people aren't going out to see those children. So that's a second problem with the anonymous reporting thing, because the person that's taking that call at central intake is not necessarily always that same person. So that being said, I really appreciate this bill for that reason. Confidentiality is important and should be protected, but the children and families who are being reported on should also be protected, and anonymous reporting does not allow that. I would argue that there's a lot more anonymous reporting than just the angry parent. When I was doing child protection in this state, and I saw a lot more of it in Arizona, there is a huge issue with, I've gotten into a conflict with you for whatever reason, and I know you have kids, so I'm going to report on you. I do have concerns about the GAL part, and the reason for that is GAL, most of the guardian ad litem, first of all, we have a huge shortage of guardian ad litems. Second of all, most guardian ad litems are attorneys. They have done some small piece of understanding child-family relationships, but they certainly aren't social workers. And at the same time, I would hate to see, and as the representative from DCYF said, I would hate to see child protection workers now taking on the responsibility of deciding what's in the best interest of the child when they specifically are there for abuse and neglect. Thank you.
Thank you. Are there any questions? All right, seeing none, thank you very much. Up next is Catherine Shea to speak in support of the bill. She's asked for 10 minutes. I'm going to ask you to cut it to 5 because we're really short on time.
No problem. Good morning, committee. Thank you for allowing me to speak. Kate or Catherine Shea from Goffstown, New Hampshire. I have to admit that I'm a bit rattled coming here today because I'm a parent advocate that speaks regularly in education meetings, but I came to relay my own personal experience, which sort of brings back some PTSD for me. 6-year divorce that was incredibly painful and nasty and didn't need to be that way. And the process that we went through did not protect us in any way. So I'm here not to talk about pointing fingers at one group or the other, or should we do this or that. I'm in support of this because it's doing something. Oh, sorry. No, sorry about that. Thank you. I didn't mean to like shine a light in your eyes there. So I normally go to a lot of hearings to speak on behalf of children. I'm an educational advocate and a state volunteer, parent of 4, 3 of them have autism. There are a lot of parents like me, and you're not seeing a lot of parents out here today, right? But it's because we don't even have the wherewithal to, we're trying to make it through every day, right? And a lot of us we have special needs kids, we end up going down this path of divorce. It's unfortunate, it's really sad, but because of other supports and services we didn't have, we find ourselves on that path. And then we find ourselves further attacked by maliciousness. So when I heard this bill was coming up, I was glad because I heard of other states that did have some stopgap measures from just a free-for-all, right? Like somebody was speaking about your neighbor or somebody at the school, and you're trying to do the right thing for your child, get an IEP, and the next thing you know, somebody's called in some ridiculous complaint. And it's hard for me to know where to start with this, but I wanted to speak from the heart to you guys today to say I'm in support of it. I have heard arguments for safety and for, all these other reasons. And as I'm helping one of my children learn about the Constitution, I have to go back to something that Benjamin Franklin said about safety. And I'm not going to go through all these quotes, but if we give up a little essential liberty to purchase a little temporary safety, we deserve neither liberty nor safety. And in our world today, we've given them up. Okay, so the people out here like me, there's not many that can come into these hearings because we're like treading water, just trying to, make ends meet and help our kids the best we can. We have sometimes special needs kids. We're taking advantage, believe me, of every opportunity out there. But when people get away with things like this and there's no consequences, it's like, I've never had high blood pressure in my life. As soon as we hit the hurdles with my kids' special needs, and we were fighting IEP battles, and then the divorce battle, and then we even had a guardian ad litem, and none of that helped to protect us. And you kind of left sitting there as an adult, almost 50, going, wow, I was really disillusioned. I thought all this was here to protect us, but we've given it all up over time. So I am in favor of this. I do think I work in IT, I work with, process re-engineering kind of things. If we can fix this process, put in some stopgaps, we are going to prevent disasters from happening and to happening to good families, right? And we can use those resources instead of them being directed to attack people for malicious means to worthwhile endeavors to help children like Harmony or others, right, that need the help. My mother was a social worker, so I'm coming from a perspective that understands social work. She was a public school teacher, a social worker. I have 2 sisters that are public school teachers. I get it, but sometimes our processes aren't working exactly as they were intended, right? Maybe we, in the guise of safety, have given too much, and we haven't put in the stopgaps that we need to have those checks and balances. That, like I said, as I teach my son about the Constitution, they were originally intended to be there, but somehow we found ourselves, even in the court of law, somebody can make something up, and there's in family court no one to hold them accountable for speaking a lie. That's not even something that's prosecuted anymore in family law cases. It's like whoever throws the lies at the wall fast enough and gets them to stick gets heard. And that's exactly what happens in these cases, especially in divorce, where it's the person out of the gates thinks they can just lob an attack. And that's what happened to me, to the point where the person reneged, and they, right in front of the social worker, said, I just, you know, he made up something. He said, I misunderstood, you know, didn't really mean it, you know, and I'm thinking, well, there's got to be a consequence. It's now happened 2, almost 3 times. So at what point is there a consequence? Or to the school nurse who decides to be nasty because she says, well, you know, your son's going to the hospital, but I didn't get medical records. Well, hello, lady, you don't get medical records. Those are protected. So what does she do? She picks up the phone. I'm going to get her back. Boom. You know, and it doesn't matter how much of it's unfounded. It doesn't matter because it sticks to you. And when you're a good parent, it does what I just said. It raises your blood pressure. It nearly gives you a coronary to come home and see something, you know, tacked to your door. It's not right that people are getting away with this. And I think that's all we're asking for as parents, is for some justice, some real consequences. If we have to face consequences in the adult world for speeding or this or that, like, certainly there should be a consequence for something so serious that someone's children could be put in jeopardy, especially mine with special needs. I can't even imagine, you know? So I'm here to speak despite, you know, it is a scary thing. And as I said, I had to face the 6 years I got dragged through something that I didn't want. But it's not an us against them. This is not a parents against DCYF. This is got some problems with the process. So, like, what can we do to fix that? And that's all I'm here to say. So thank you for your time. Do you have any questions?
Are there any questions? Representative Yokella.
Thank you, and thank you for taking the question. If there's a lot of discussions about GALs and confidentiality versus anonymous, do you think that if those things were stripped out of the bill and it was just a punishment on the books and the DCYF people on the phone saying, if this is false, there could be consequences, do you think that's enough to say that this is moving us in the right direction, and then we could come back if there's still issues to maybe enhance those protections further? Let's say if DCYF has multiple cases that they're saying, you know, they're anonymous and we weren't able to prosecute them, but we know that they were abusing the system, so we need some more, you know, strength in that aspect. But do you believe that it's necessary right now, or do you think that we could take this a baby step and it doesn't necessarily need to be all or nothing in this case? Thank you.
I think it needs to be bigger than a baby step, because we kind of have the baby step now. If you were to get your records, you can, I mean, some names are redacted and whatnot, but you can essentially figure out who is saying what. You really can. It doesn't, you know, it's not rocket science, but what I do think is there's too many people hiding behind layers of confidentiality or not, and I can't say the word, being anonymous. You know, for an example, in one of my situations, the person knew somebody on the inside and they used a mental health worker. So not only are they anonymous, but they're hiding behind a mental health worker now. So you got 2 layers. Like, there's multiple layers of protection, but for the person on the outside of this, there's none. So I think we have to do better than a baby step. For the GAL, you know, having gone through that process myself, I mean, I heard someone else speak about this. They are attorneys. You quickly learn in going through a family law case that you're paying for the vacation home for the attorneys, essentially, right? They're building a home I mean, my case alone, $30,000 both sides easily, without even paying the GAL, you know, and we are not a family of means, you know, so it's devastated us. But the GAL was an added expense, and it, you know, honestly, it was something I was advised by my attorney to get, and it didn't come back to help me one bit. There was no added value. You know, I'm not necessarily opposed to GAL, but adding overhead for the sake of overhead or oversight, I'm not a big fan of that. So I think we need other measures in place and not just rely upon somebody to enforce it or this department to do that or adding another position. There's got to be some incremental, you know, warnings along the way. I do know Wisconsin will send a warning, I believe, when somebody makes a complaint, and they send them back a letter, I believe, with something to the effect of, be aware that this is a punishable offense if you're making a false complaint. So, I mean, there's other options out there, but I think it needs to be stronger than just, you know, the change in the level of information that's allowed to be provided. Did I help answer your question?
Are there any further questions? All right, seeing
Thank
none,
you.
thank you very much. And up next, we have J.R. Hall to speak in support of the bill, who's asked for 5 quick minutes.
I'll do my best. Thank you, Madam Chair. For the record, J.R. Hall, former state rep, former member of this committee. I ended my service in 2018. I'm here to speak in favor of House Bill 1612. I'm going to skip over Section 1. I have no opinion on that. My wife and I are happily married and with 4 children, and this seems relevant to divorce proceedings, so I can't make an opinion on that. I want to speak to Sections 2 and following. I'm living through this nightmare. Because of a gag order, there is very limited information I can share about what's going on in my life. I can tell you this started as an anonymous report at some level. Okay? It was not hard to figure out where this started in my personal life. Okay? Confidential allows for someone to come back later on and figure out where this started and depose them in a courtroom if necessary. There's a huge difference between someone making hearsay evidence that starts an investigation and then someone being able to call on that person to substantiate that. Our Constitution is extremely clear, Part 1st, Article 15, that no subject shall be held to answer for any crime or offense, and in some cases, DCYF is pursuing both criminal activity, okay, as part of their jurisdiction, okay, crimes against a person that are significant enough that someone should go to jail. And then they are also doing civil level cases where it could almost be a matter of parenting. I will go back to reading the Constitution. No right shall be answered for any crime or offense, and the civil stuff falls under offense, until the same is fully and plainly and substantially and formally described to him, right? And it goes on to talk about the fact that we should be able to have that person, right, to be able to cross-examine that person. As I said, I because of a court order, I'm limited in what I can share right now. But I can tell you confidentiality is what drives some of the corruption into this system. That if there was more transparency about what was going on, as Representative Long said, it might diminish a little bit about the reporting. That is a legitimate concern. However, if there is real harm, the person who's making the mandatory reporter, the person who is calling into the system, has a reason to want to make that phone call. There's not going to be a concern about sharing that information. I would also like to say I have one concern on Section 4, just from a straight drafting point. Okay, and this is the last line. Okay, under no circumstances shall the identity of the complainant who made the report of suspected abuse or neglect in good faith or pursuant to RSA 169C29 be released. That's overly broad. It should be released publicly. At a minimum, right, it should be allowed to be given to the respondent so that the respondent in these cases can talk to that person or have that person put on a stand. There is no way to have justice if one side says, hey, I've got some information, but I'm not going to be able to share it with you, tell you, I just know that this person has done something wrong. That does not give us the transparency and the justice our system deserves. I would ask that this committee, been to court a lot, ask that this committee pass this bill. I don't know about Section 1. I'm not going to speak to Section 1, but Sections 2 through the end, with the one exception of the change that I asked for about that last line, be passed. I would go further, that the language should be even more clear, that the confidential name could be and might be released to the respondents if this matter is found to be founded and to go forward into a court proceeding. Because at that point, the mandatory reporter should know that they're going to be potentially on a witness stand. But if they have real facts that they're reporting, then they should be allowed to make, right? They should be willing to stand up for what they believe to be true. If they're not, this might be, and this is how this whole thing filters out the alleged, right, the false allegations. They're not going to be willing to go to court over a false allegation and put themselves in risk of perjury. So I thank you. I again ask that you support this bill, and that would be it.
Okay, so I have a quick question.
Absolutely.
So who is responsible if that name gets out and that person ends up killed by the person? I mean, it's real. Domestic violence is real.
Right.
And if that name gets out, someone's going to get killed. And I would also bring up, a certain case that's in the media now. I would take one look at that person, see a teardrop tattoo, and be in extreme fear for my own safety if my name got out there as the reporter of that abuse to them.
So
that's where I want to know who is then liable when someone gets killed.
Well, if someone is killed, the person who committed the murder is liable, right? But I think the point here is there is ways under the confidentiality statutes of C25, right, 169-C25, and other places under 170, okay, to keep certain information within what happens to the court. But the respondent should always be allowed to know who made the report. And if the respondent is the one who commits murder, right, that person is going to jail.
But would you not agree that the state has put someone in jeopardy by giving that name out? I have real concerns about that.
If there was an actual report where there was harm done, right, criminal harm in most cases is what the basis is, and that mandatory reporter, be it a person, right, be it a public official, be it a medical professional, whoever, right, be it, I don't know, a teacher or a librarian or something, okay, if they actually had real concerns, there's lots of things they could do if they knew their name was going to be out there. They could, in fact, ask for a protective order to make sure that the respondent, right, is not allowed near them. There's a lot of things they could do to protect themselves if necessary. If there is true harm, and I think that's the thing is, statutes are hard to write. I sat up here for 8 years, okay, because there's a lot of the 1% on both extremes in terms of the cases that make it hard to write legislation. Because on one case, and with good, I like your question, because you could have a case where someone is fearful of their life in terms of, if I share this, I know my cousin, for instance, might come back and try and harm me. I'm not saying that personally, I'm giving that as a hypothetical. So I can see that concern, especially where there may be a mismatch between genders, right? It may be a female who's concerned about an overly aggressive guy, right? The typical way someone sees this. I can see that. But I can also see where someone hides behind the current confidentiality the current anonymous statutes and aggravates a divorce that's going on in family court or another type of case. And I can say with absolute certainty, I've never talked to DCYF. They've never talked to my family until 8 weeks ago. The first case record was of this case. There was 0 before that, okay? But I can also see what's going on in terms of how they pigpiled on top of that in terms of other reports that have nothing to do with it. The anonymousness, and fortunately the judge was willing to say something like, no, I want the names of everybody released in this case so the respondent can at least figure out whether they need to be on the stand and questioned. So my point here is, as you guys draft this bill, understand the bill has to cover a very broad spectrum, and the false reporting is the concern right now. And how do we mitigate that? How do we make sure that if someone is maliciously accused of a crime or of abuse or neglect, that they have a chance to cross-examine their accuser appropriately, or at least in a deposition? They may not be able to do it in a court, but their attorney could do it in a deposition. Okay.
Are there any further questions? Representative Long?
Thank you, Madam Chair. Thank you, Mr. Hull. I mean, do you agree that malicious or intent to harm is a high bar to prove?
Thank you for the question, Representative Long. I do. malicious is a very high bar to point to.
And if I could follow up, in section 4, you're asking that there be no anonymity on any reporting. Is that
No,
is that what
no,
you're asking
that's
down here?
not. Thank you for the question. No, what I'm saying is in lines 27, 28, okay,
Yep.
that currently the way I would read this, okay, it would prohibit that information from being shared at all to anybody within who's a party to the case, and I'm not sure that that is actually what the bill was intending to do. Right? Be released means publicly as opposed to the parties in the case.
Right. Okay.
And I think if you were to do this, right, you could inadvertently wipe out some of the other things you're attempting to do, right? So it's just it's a clerical thing more than an intent thing, right?
Okay. Very good. Thank you.
Representative Yokella?
Thank you, and thank you for taking the question. It seems to me that you're suggesting that there is more than one reason for collecting this information. It seems to me that the information is being collected in this bill so that if there was malicious intent with the reporting, that could be filed and charged against that person. And you seem to be suggesting that the person that is reporting the things that they saw to DCYF or have reason to believe to DCYF that is that the purpose of getting that information is so that it can be used in court, whereas I think and you were talking about responding to the person essentially alleging a crime, and it's my understanding that DCYF takes in that information and they go and do the research, and they are the one that actually go to court and allege the crime, not the person that originally said, "Hey, something fishy might be going on here." Is that your understanding?
That is correct. Let me restate, right? In most cases, it is DCYF that is 99%. The reason that I can bring up another case, right, when it becomes a medical neglect issue, okay, the testimony of the initial reporter is significant and important, which is different than, let's say, I called, right, hypothetically again, I called because I was concerned about the screaming I heard at my neighbor's house. My neighbors are fine. There's no screaming going on. But, right, there's a difference there. But I think taking the information on has multiple values. The most important of which is if DCYF needs to follow up with that person later on, all of that information is available to do so. Excuse me. Secondly, if this matter moves forward, because there is some basis to move forward, there is the opportunity for the respondent in these cases, okay, or if it ends up being a criminal case because the alleged abuse is greater than just civil in nature, the defendant, you would have a chance for that person who's on the responding end to be able to cross-examine them in a court, okay, because there may be firsthand evidence of that initial reporter that has to come out, as opposed to the person who's pursuing the charges, right? DCYF acts kind of as the prosecutor in this sense, as opposed to the person who was the first-hand witness. They are a second-hand witness in all. They take the information, they write a report, much like the police do, but they were not the first-hand witness. So there might be a need to have a discussion with the first-hand witness later on. Does that make sense?
Thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you, members. of the
Okay, so
committee.
I'm going to close the public hearing on HB 1612, and I will open the public hearing on HB 1280, and I have no pink cards, so can someone just introduce this bill really quick for me? Because it has to be introduced before I can even take a, it's Terry Roy's. Yeah, go ahead. It's 1280. You don't even have to speak to it, you just have to introduce it. Okay, Representative Spillane, thank you very much.
Thank you, Madam Chair, members of the committee. I am introducing HB 1280 on behalf of Terry Roy, the prime sponsor, because he could not be here to do so.
Thank you very much. So I'm going to call on Lisa Lipkin, who's asked for 8 minutes to speak in support of the bill.
I'm going to read a statement. If I read a little quickly, it could be less than 8 minutes.
Okay.
Honorable members of the committee, thank you for taking my comments in support of HB 1280. For the sake of time, I won't take a poll, but I imagine that many of you are parents, and those who are not are beloved aunts, uncles, and family friends. From that vantage point, you understand the unique, nearly boundless love you have for the children in your lives. This love is universal, lifelong, and pervasive. It is the norm. In the mental health field, it is well known that the loss of a child is the most catastrophic trauma that could befall a parent. Conversely, for children, the loss of a parent is emotionally tantamount to their own death. Therefore, any externally imposed separation, i.e. termination of parental rights, must be considered in this scale. The fact is, most parents dearly love their children and do everything in their power to help them grow and thrive. Are there exceptions? Of course. But they are fewer than you might imagine. I ran some numbers. In 2019, the U.S. Census stated that there were 73.1 million children in the United States. According to the U.S. Department of Health and Human Services, in that same year, there were 656,000 cases of abuse or neglect in our country. Now let me be clear. Every single incidence of child abuse or neglect is one too many and thoroughly unacceptable. But here's the important perspective. Those numbers calculate to 0.0089%. That means less than 1% of U.S. children are actually abused or neglected. A little bit of a relief. So let's now place that knowledge around the current pressure exerted upon parents to vaccinate their children with an experimental shot that has no long-term safety data and is showing alarming side effects, including death. It must be said that all vaccines carry risks, including the risk of death. The independent peer-reviewed data in support of not vaccinating children is enormous. But I am not going to focus on general vaccines right now. I'm just going to focus this testimony on the COVID-19 vaccine. More numbers. A Harvard study done a few years prior to the onset of COVID-19 concluded that somewhere between 1 and 10% of adverse reactions are reported to the Vaccine Adverse Event Reporting System. This is the CDC's own database designed to track vaccine injuries. Given that Harvard study, we can be certain that the following numbers, presented by Wisconsin Senator Ron Johnson in a press conference this past November, are well below the actual data. Calculated over 25 years, the total annual adverse events for the flu vaccine averaged 7,596 with 76 deaths. Total deaths from the flu vaccines over that 25-year period is 1,996. 25 years of flu vaccines, less than 2,000 deaths. Again, every death is a tragedy, but less than 2,000 deaths. Contrast this with 10 months of the COVID-19 injection. Adverse events reported are 818,044. This is in November. That is 108 times that of the flu vaccine, with 17,128 deaths. That number of deaths is 225 times higher than the annual number of deaths from the flu vaccine. This injection is a completely different creature. As it relates to children, Dr. Robert Malone is a U.S. virologist and immunologist who has dedicated his professional existence to the development of mRNA vaccines. In December 2021, he made a public statement. The entire transcript is here, and I can give you guys for copies, but I'll just be a little briefer and give just a few highlights. Dr. Malone says, before you inject your child, a decision that is irreversible, I want to let you know that the scientific facts about this genetic vaccine, which is based in the mRNA vaccine technology I created. There are 3 issues parents need to understand. The first is that a viral gene will be injected into your children's cells. This gene forces your child's body to make toxic spike proteins. These proteins often cause permanent damage in children's critical organs, including their brain and nervous system, heart, muscles, includes blood clots, their productive system, and this vaccine can trigger fundamental changes to their immune system. The most alarming point about this is that once these damages have occurred, they are irreparable. You can't fix the lesions in their brain. You can't repair heart issues. You can't repair heart tissue scarring. You can't repair a genetically reset immune system, and this vaccine can cause reproductive damage that could affect future generations of your family. The second thing you need to know is that this novel technology has not been adequately tested. We need at least 5 years of testing/research before we can really understand the risks. Ask yourself if you want your own child to be part of the most radical medical experiment in human history. One final point. The reason they are giving to vaccinate your child is a lie. Your children represent 0 danger to their parents or grandparents. It is actually the opposite. Their immunity after getting COVID is critical to save your family, if not the world, from this disease. The risk-benefit analysis isn't even close. As a parent and grandparent, my recommendation to you is to resist and fight to protect your children. In conclusion, 99% of parents do not abuse or neglect their children. Neglectful, harmful parents are not the norm. Rather, it is the norm that parents work overtime to protect and provide for their children. And those parents should not have to fear that a government agency who is often not well informed, not aware of the dangers of vaccines, and who does not love or even know your child could jeopardize your parental rights over this issue. Or worse, could literally take your child away while you are desperately trying to protect that child. Exactly the way any fully informed, loving parent would. Exactly the way each of you would. I'm encouraged and optimistic that this bill is being presented, and I look forward to seeing it pass. Thank you.
Thank you. Are there any questions? Representative Long.
Thank you, Madam Chair. Thank you for your testimony.
Thank you.
So I mean, this isn't COVID specific, so
Sure.
that just kind of, I'm more specific on the, I mean, currently there are vaccines being used. I haven't heard of anybody's termination of parental rights for not getting the other vaccines.
Wonderful.
So I'm looking to identify the problem and the need for this bill. Well, I mean, has there been termination of parental rights for current vaccine requirements?
Oh, I don't know. I mean, I'm just speaking to the bill as proposed in support of it.
Okay, great.
I don't know the history
I'm
of the
good.
bill. I'm actually fairly new to New Hampshire, so I don't,
Okay.
yeah,
All right, thank you.
okay.
Are there any further questions? Seeing none, thank you very much.
Thank you.
Up next is Stephen Daves to speak in support of the bill. And he's asked for 5 minutes.
Thank you for the opportunity to speak. Yes, I'm a husband and father of 3 children. I personally am pro-choice for vaccines. I choose to vaccinate. However, I would not, under any circumstance, want somebody's children taking from them. If a parent chooses to use their right of conscience to not vaccinate their children, instead, this is something that we can use persuasion rather than coercion to convince them. Specifically, the New Hampshire Constitution guarantees our right to privacy and our right to conscience. So it's very disheartening that you wouldn't support a bill that would further the rights of the parents and the rights of families. It is the role of government to protect our rights. And if at any point you felt that this bill would protect the rights of parents, then you should support it. However, if you feel that it is the role of government to have the power to take away people's children from them for doing what is against their conscience, then I would please ask that you question your position, because it is the role to protect our rights. So, thank you. And if you have any questions, go ahead.
Representative Patrigno.
Thank you, Madam Chair, and thank you for taking my question. So strep throat is pretty common among young children. And if it's not treated with antibiotics, rheumatic fever, which can damage the heart, is a potential cause. Inflammation of the kidneys is another cause. Would it be appropriate for parents to exempt their children from antibiotics? And if so, then when we make a comparison to vaccinations, wouldn't it be neglectful to put children in harm's way not to get vaccinated or to get antibiotics, or for that matter, any medical treatment if the parent so chooses? Would that be neglectful?
I appreciate the question. It is definitely moving the goalpost off of the bill at hand, which is specifically limited about vaccinations. But at the same time, I would challenge you to find parents that don't want the best for their children, more so than the people sitting in this room or any rooms in this building. Parents spend sleepless hours thinking about what's best for their children. Do they get it wrong? Yes, sometimes they do. Personally, I'm also against spanking and smacking your children, and there has been several countries that have made that illegal as well. However, it's perfectly legal in all 50 states to hit your children every single day if you don't like what they do. And I don't believe anyone on this board thinks that parents should lose their parental rights for spanking. But there are several, some do, right? However, many don't, I'm sure as you're aware. And there are, what's that?
I don't think I said that.
I did.
Oh, okay.
I'm sorry, right here. Yeah, there's a difference of opinion, right? So the same is true for what are the ramifications for medical procedures. The same is true for what are the ramifications for smacking and spanking your children. There's negative cognitive problems. There's behavioral problems that could cause sociopathy, right? Which are societal problems that could result in mass murders, mass shootings, which are far worse than somebody getting sick and dying because their parents chose not to vaccinate them or give them antibiotics. I believe that this is the role of medical professionals, primary care physicians, to talk to parents and for parents to find primary care physicians that they trust, as I've done. I found primary care physicians that I do trust, and that is how this relationship works. So I hope that answered your question.
Are there any further questions? Representative Long.
So thank you for taking my question, and thank you for your testimony. I'm still trying to identify the problem. With respect to spanking, there are parents that have been terminated because it was claimed to have been abusive. So I'm still trying to identify where, I mean, what I'm hearing is that we should be putting in these bills. I don't agree with spanking, so I should be putting in a bill to stop spanking. So I don't, I'm just trying to look for where this bill is needed. Is that, what is the problem that this bill needs to be?
This bill is a chance for representatives to stand with parental rights. So most of you, some of you may be parents, thinking of being parents or grandparents, and I'm sure you have an idea of what you want for your children and your grandchildren. And you hold your idea very highly because you've probably thought about it a long time. But at the same time, if you believe that your neighbor should be doing something, you have a conversation with them. You tried to persuade them. And this gives the opportunity for persuasion rather than coercion. It bans coercion of DHHS from holding something over a parent's head, saying, if you don't do this thing that we say, which may or may not help the child, it possibly likely would help them, but we're not sure. And specifically, it's difficult to, so if we do reference, like the last testimony, if we do reference this specific COVID vaccination, which is, I think is probably the motivator for the bill, right? More so than any of the other vaccinations. It's difficult to trust the pharmaceutical companies who tell you that there have been 0 deaths during trials, and then from Freedom of Information Act requests from December 1st, 2020 to February 18th, it turns out there were over 1,000 people that very likely could have died from the vaccine, after previously they said that there were no deaths. And then after requesting more evidence from their trials, they say it'll take 75 years for us to release all the documents to the public. So there's already this scenario of protection for pharmaceutical companies, specifically passed in 1988 with the Child Vaccine Safety Act, which prevents pharmaceutical companies from being held personally liable to lawsuits. It's a really weird scenario to think that you can make a product, force it on people, and then you can't sue them if you're damaged from it. There's very few other industries where the tort claims, the right of protection from damages, does not exist. So specifically, that's why this bill should be supported, because of the existing legal environment set up in the United States to protect the pharmaceutical companies from lawsuits.
Okay, thank you.
Are there any further questions? All right, seeing none, thank you very much.
Yep, thank you.
Up next, we have Mary Smith, who has asked for 2 minutes or less.
Thank you, Chairwoman, and the committee for hearing my testimony today. What this bill addresses is that parents have the right as stewards of their children to make medical decisions for their children, not the state. This bill seeks to affirm that basic notion that governments are instituted to safeguard rights, not demolish them. To speak to Representative Long's point about what is the need for this bill if there have been no recorded instances of anyone's parental rights being taken away on the basis of vaccination, I would say that I don't have those figures or numbers in front of me, and that's an excellent point. And it speaks to the sort of underlying point of the legislation that I think other people have tried to communicate adequately, and maybe they haven't communicated adequately, is we're not sure, we don't know, but it is evident or clear that recently in public discussion has included whether or not parents should be considered negligent in their care of their children if they don't take steps that would safeguard the health and the life of their children. And one of those steps could plausibly be vaccinating or not vaccinating their children. So given that vaccination can lead to a child not contracting a disease or not contracting a disease as severely as they might without vaccination, I think that is the impetus. That is the reason why parents are interested in this, that this bill has been submitted, that I'm here to testify for it, and so were other parents before me. So hopefully that clarifies. Any questions?
Representative Yokella?
Thank you for taking the question. Is vaccine, the medical decision regarding vaccine, unique in recent history, examples of judges requiring vaccine, taking a vaccine to be on parole, or deciding who has parental custody based on whether or not they are going to provide the vaccine to the child? Are those unusual cases that maybe we would not have seen before COVID, and therefore this bill would not have come up unless stories like that had been presented, come to the forefront of I guess, our societal consciousness?
To answer your question, I think the answer would be yes, that this has been unusual and probably infrequent before COVID, but now, due to COVID and COVID vaccines and the controversy and the different feelings that different parents have about what is best for their children, that now you are going to be seeing many more instances where you have an entirely plausible case, where people can go to the state, like parents in a dispute can go to the state and say, well, this parent who I'm fighting against for custody of my child has clearly shown negligence or disregard of the health of my child because they have prohibited or blocked us being able to get a vaccine or have them be vaccinated. And so it may well be the case, as you pointed out, that because it wasn't in the public consciousness as much, that these cases may have happened, but they may have been infrequent and may not have been the cause for legislation in the past, but are now, because it is such a sticking point. It is at the top of mind for so many parents and so many legislators. So,
thank you.
Are there any further questions? All right, seeing none, thank you very much. Up next is Ribson Chester. She didn't put how much time, but you got about 3 minutes.
Thank you, Madam Chair. Thank you, committee members. I just wanted to say that this isn't new. When I worked for DCYF, there are some people, for whatever reasons, they choose to not want to necessarily follow the vaccine process. They have been accused of being neglectful and or medical neglect specifically, and they have come to the attention of DCYF right here in New Hampshire. In some instances, they have a good reason, but they still are not always successful. So I had one person who is absolutely convinced that her 2-year-old round of shots caused autism in her son. I'm not going to be able to convince her otherwise. She had another baby after, like 2 years later, so she refused to get the other one fully vaccinated. She only wanted to spread it out. She was still brought up on charges of abuse and neglect. She still went through the system. Her children were put in foster care, so this is real. And yes, COVID has opened pulled the curtain back. But the other thing that I would say is because there's not a lot of statistics, because unfortunately Child Protective Services hides behind a veil of confidentiality. That again speaks to, it's very easy to say, oh, it's not a big deal in our state because no one can talk about it. The other thing is that I know right now there is a situation where, and it was with regards to the COVID vaccine, but a parent felt that 50-50 custody. One parent had felt very strongly that they wanted their child vaccinated. The other parent felt very strongly that they did not want their child vaccinated. So they brought it to the courts, and the judge ruled. That child has now suffered some symptoms from the COVID-19 vaccination. Don't know if it's going to be temporary or permanent. However, something like this would protect children and parents. The bigger thing that I see in that two things where the parents are fighting about the vaccine issue, that child's being maltreated because they're not able to work with their parents and come up to some kind of solution. So that being said, that's why I like this bill coming forward, because it is something in our state, and it goes back to any kind medical treatments. If you have an experimental medical treatment, same thing, difference of opinion. So
Thank you. Are there any questions? Representative Long.
Thank you, Madam Chair. Thank you for your testimony. So you're telling me in New Hampshire, somebody refusing to get vaccinated is medical neglect, and they took their children and put them in foster care?
That was the case, yes.
That was the
that
case.
that actually happened. That was a real life. It hasn't happened recently, but we've done so much to deteriorate our parental rights in New Hampshire. I wouldn't be surprised if it's happening today.
Thank you.
So speaking of parental rights, would you not then say that the other parents' parental rights are being deteriorated if they choose to if they want their child to be vaccinated?
And I agree. All rights should be considered, both parents' rights and the children's rights. So it is a sticky wicket. I'm not saying that Child Protective Services shouldn't have been involved. What I'm saying is that because of this type, the lack of this statement, there's one parent's rights are being outweighed over the other. This would allow people to make a decision, because in some cases, one parent's right, they may have a very good reason. That woman had a very good reason for not wanting her child vaccinated. In this situation, the parent that wanted her child vaccinated, they're not involved with DCYF. The parent that wanted the child vaccinated is based on the information she has, and the one that did not, based on the information they had. The appropriate thing would be to do in that situation is to create a mediation and to try to see if we can come to some kind of an agreement.
Thank you. Representative Yokella.
Thank you for taking the question. Shouldn't or doesn't the decision about the cost benefit for each individual vaccine, and even the history with the child or previous children, as you said, weigh into the decision of whether or not a parent might vaccinate their child, and maybe even the timeline for which, because it seemed to me that there has been some discussion about whether or not spreading out the vaccines over a longer period of time, or letting the children choose that at an older age might be more appropriate in that individual circumstance. Do you believe that should be that there is a range of choices that may be argued and valid, and it's not it shouldn't really be a deciding factor about whether or not the children are removed from the parental care?
Yes, thank you, and I appreciate the question. So the reason why I'm speaking on this is because it's the most egregious form of termination of parental rights is devastating. It's devastating for the biological parents, it's devastating for the child, and it's devastating for even the child protective worker that's been involved. So that's why I like that it's just specifically for termination of parental rights. This doesn't prevent someone by making appropriate decisions for their children, nor does it force any coercion on either side, because you still have that process that you can work through with the termination of parental rights. That's after it's been quote unquote proven through the court process that it's not in the best interest of the child to maintain a relationship with that parent. Did I answer your question?
Thank you. I would like to
Follow up.
Thank you.
Yeah, it seems like you're in that last statement where you're talking about that terminating the parental rights is essentially saying it's not in the best interest of the child to be
To maintain
parented,
that relationship.
maintain that relationship, and your testimony to this committee is that that vaccination and decisions about that is not enough of a detriment to the child to warrant the removal of that relationship?
Vaccination in and of itself, I do not believe it should be.
Okay,
Unfortunately, I just think that that's what's happening.
Thank you.
Are there any further questions? Seeing none, thank you very much. Okay, so I'm going to close the public hearing on HB 1280, and we will be back at 1:15. All right, good afternoon. I'm going to open the public hearing on House Bill 1651, and we'll call on Representative Dave Testerman, who's asked for 5 minutes.
Thank you. As you said, my name is Dave Testerman. I'm a representative for Franklin Hill in Ward 2 of Merrimack County. Today I've got a bill to introduce to prevent abuse of children. I'm not here to argue about whether you can give various toys or clothes or dye your hair, whatever you want to do. That's not it. I'm talking about chemical and physical abuse of children who will have a lifelong dependency either on drugs or a lifelong change if they've had a physical operation. The RSA, or excuse me, the bill merely adds a definition to abuse. It says if you use drugs or physical therapy or physical changes to a child, it's called abuse, and that's just it. So, any questions?
Are there any questions? Seeing none, thank you very much. Up next is Stephen Scar to speak in support of the bill. Oops, there you go. Did I pronounce your name wrong? Scare. Stephen Scare, sorry.
Okay, Stephen Scare, 111 East Hobart Street in Nashua, and I'm here to speak in favor of this bill. The strongest advocates of putting some limits on child transgenderism you'll find if you go to the subreddit for people that have gone through detransition, and right now it has almost 26,000 members. And something that they emphasize is you can't tell, no one has any way of telling who's going to regret what's happening with the gender blockers or cross-sex surgery or double mastectomies later. There isn't any clear science behind it. I realize some people are happy with it. But they point out that being that young, they were unable to make informed decisions. And they tell a common story for young women is that they had trouble fitting in with other girls. They didn't fit female stereotypes. They were drawn into transgenderism by social media and peer groups, and then just rushed through medicalization by therapists who didn't explore other concerns. One woman, Laura Reynolds, she's a detransitioner. She has a child now. She regrets not being able to breastfeed, and of course a change to her voice and some of the other changes to her body. She says children don't have free will. They'll believe anything. If you tell them they can change their sex, they'll believe you. And just briefly, one other reflection that's running on the subreddit page expressing frustration from someone who went through child transgenderism herself. Why have trans activists pushed so hard for immediate medicalization of anyone who is experiencing even minor forms of gender discomfort dysphoria, encouraging a lifetime of doctors, blood tests, scans, injection surgery, even more surgery, instead of just trying to talk therapy first? Would it be ethical to staple the stomach of a 14-year-old anorexic shut so they can't gain any more weight, even though there's nothing wrong with them physically, and the problem is all psychological? Seems insane, but that's exactly what we're doing to trans kids. Permanent changes from a problem that isn't even real a lot of the time.
Sex can never be changed, and no matter what surgeries and unhealthy medical procedures you do to people, it will never come close to the bodies given to us at birth. Yet we throw all that away because of a thought that we were born in the wrong body. How can it be wrong if it's perfectly healthy and functions by itself without need for medical intervention? Doesn't make sense. So thank you very much for this opportunity to speak.
Are there any questions? Seeing none, thank you very much. Up next is Chris Urchel. Did I pronounce that right? Representing GLAAD.
Thank you, Chairperson, members of the committee. My name is Chris Urchel. I am an attorney with GLBTQ Legal Advocates and Defenders, which is New England's premier legal advocacy organization for LGBTQ equality. And I'm here today to speak in opposition to HB 1651. I'd like to start by drawing the committee's attention to House Rule 36E, which states very clearly, in the second year session, no bill or resolution shall be introduced if it is substantially similar to any legislation that was indefinitely postponed or voted inexpedient to legislate by the House in the first year session. This bill is identical, indistinguishable from HB 68, which was introduced last year, and it is in blatant, flagrant violation of the House rules.
Thank you for bringing that to my attention. I didn't even think of that because the whole first year was very confusing. So thank you for bringing that to my attention.
You're welcome. I would like to go on to say that transgender people in our community, they're assets to our community. They are our neighbors. They are parents. They're participants in our workplaces, in our communities, in our libraries. They volunteer. They are friends. They're family. They're everywhere. And they can be really productive and helpful and wonderful contributing members of our community, but only if they have the tools that they need to succeed. And if we deny them those tools to be successful, happy, healthy, contributing members of our society when they're children, they have little chance of being successful as adults. Gender dysphoria is a serious medical condition. It's widely accepted by every single medical organization in the country and in the world, in fact, that gender dysphoria, I don't need to rely on a subreddit to make my case. Every major medical association agrees that gender dysphoria is a very serious but very treatable medical condition. The condition manifests because of an incongruence between a person's assigned sex at birth and their gender identity. Treatment for gender dysphoria, not just any discomfort with one's gender qualifies as clinically diagnosed gender dysphoria. There's criteria that are laid out in the DSM-5. It's been available for years to any practitioner to understand what the diagnostic criteria are. When someone's diagnosed with gender dysphoria, there's medical standards of care that are applied to treat somebody with that condition, and those include different forms of treatment, which vary from social transition, like using a different name, pronouns in different settings, dressing a certain way. There's hormonal treatments, there's surgical treatments. There's also legal avenues that people can take to get updated identification documents to reflect who they are. All of those are under the general umbrella of gender transition, which is treatment for gender dysphoria. It's extremely effective, and every single medical organization agrees. I'm not a doctor, so I'm not speaking from that perspective, but I can guarantee you that there is no major medical association that disagrees that gender dysphoria is highly treatable and the treatment is gender transition, which this bill would turn into a criminal act. So it's such an extreme way to react to that. At the same time that we're having this hearing, in an hour, there's going to be a hearing on a bill by the same sponsor to repeal the ban on conversion therapy.
Okay, but we're sticking to this bill,
Yes,
okay?
no, I understand.
Thank you.
I'm bringing it up because the conversion therapy ban that this legislature passed back in 2018 was meant to address the fact that there are people who, to this day, despite mounds of evidence, to the contrary, there are people who to this day believe that the correct way to treat transgender and gay youth is to try to convince them or force them to change their gender identity or change their sexual orientation. That persists to this day, and that's just what this bill is manifesting right now. And just for broader context, we are in the midst of a massive attack on transgender youth across the country. Bills in every single state legislature that are aimed at harming transgender youth, and this is just one more of them. And I hope that this committee votes decisively like you did last year, 15-0, unanimous ITL. I hope that happens again this year. Thank you so much for listening to my testimony. I'm really happy to take questions if anyone has any, and thank you for your time.
Okay, are there any questions? No? Okay, thank you.
Thanks.
We're going to take a 5-minute break because I wanna check on the policy with the House rule. So give me 5 minutes and we'll be back at 1:31.
Oh, is that what happened then? Interesting, because the docket shows that it was taken off of consent, but it doesn't say what happened after that. That's what happened after that.
It was at the end of the session, the leadership decided they were just going to leave some bills, and because of that, they've decided that, yes. Yeah, exactly. So they're treating it as if it had been tabled. A tabled bill can be brought back to the subcommittee. So effectively, because it wasn't acted on, it didn't meet the deadline. So to act on it would have needed 2/3 of being passed at once. So it just kind of simply was. Yeah, they actually on the website they have it labeled as different stuff. The retained bill is different than a tabled bill. But they're treating it as if it were a tabled bill. It's identical, so they're just saying, yeah, and actually when you bring back a new bill for a tabled bill, you're allowed to use exactly the same language. Yes.
So the rule says indefinitely. The rule says indefinitely postponed.
Right, they're not treating it as indefinitely postponed because there was no vote. Indefinitely postponed is a specific motion. Right. Indefinitely postponed does kill it, yeah. Tabled, no, and they're treating this as if it were tabled. So, I sent them an email about this, but I sent it fairly recently and they may not have had any chance to think about it. But anyway. Huh? No, I mean, I don't think they can, at this point, with the leadership having allowed it, they got through legislative services, and the leadership allowed it, so we're gonna have to hopefully vote 15-0 again, as you said. That's what I said to them too. How about staying and listening? Jeez.
At least you stay to listen. Last year he snuck the word out, but
Oh yeah, I remember. or 5 years ago, he was already mentioned in this bill and being treated the same.
Okay, we are back. So I made them aware. I mean, now that it's a bill, we have to continue, but I made them aware, and they're going to look into it and stuff. So thank you for bringing that to our attention. Okay, so up next is Holly Stevens to speak in opposition to the bill. She has written testimony representing NAMI. That sounded weird. I didn't say it right. NAMI. It kind of came out NIAMI.
That's okay. How would you like me to get you these?
You can just start here and we'll pass them around. I'll reach out. Thank you. I just love getting to those, so.
Chair Rice and members of the committee, on behalf of NAMI New Hampshire, I'm here to speak in opposition to House Bill 1651, adding sex reassignment to the definition of child abuse. For the record, my name is Holly Stevens, and I'm the Director of Public Policy for NAMI New Hampshire. Specifically, I wanted to talk about the high risk for depression, suicide attempts, and suicide deaths for individuals who identify as transgender. By way of background, I'm sure if you've heard our past executive director speak, Ken Norton, he's talked a lot about NAMI New Hampshire's Connect Suicide program. It's a program that's been designed as a national best practice in suicide prevention, intervention, and postvention. And they've used it to train in over 40 states and 35 tribal nations. NAMI New Hampshire and the Connect staff serve on numerous national and local work group committees, including the National Prevention Lifeline, as well as New Hampshire's legislatively established Suicide Prevention Council. Just wanted to provide the background about the extensive knowledge that NAMI New Hampshire does have on the public health crisis of suicide. For individuals in our state that are ages 10 to 34, suicide is the second leading cause of death. And it's only the tip of the iceberg when you're, looking at suicide attempts. And the human and economic impacts of suicide deaths and attempts is very significant. A small but important subgroup of these individuals are people that are dealing with gender identity issues. And there's an emerging body of research that's showing that trans people are less likely to attempt suicide. I got that completely backwards. They are more likely to attempt suicide than their peers in the general population. Young people who are non-gender conforming are also at a higher risk. A 2021 study indicated that people who undergo hormone therapy or gender-affirming surgery have significant reductions in psychological distress, including suicidal thoughts. There have been previous studies on suicide rates of individuals who identify as transgender that show that some of the unique factors that contribute to that this population faces. One of those factors is a lack of family and social supports. Adding hormone therapy and gender-affirming surgery to the definition of child abuse takes away a parent's right to support their child as they see fit. As I previously stated, a lack of family supports contributes to the increased risk of suicide in the young transgender population. And if passed, House Bill 1651 would be harmful to the mental health of these individuals. And as I previously mentioned in those studies, it is likely to lead to an increased risk of depression, suicide, and suicide attempts in this population. And because NAMI New Hampshire is committed to addressing suicide as a public health issue and reducing the incidence of suicide thoughts, attempts, and deaths, we respectfully urge that this committee vote inexpedient to legislate on this bill. Thank you for taking my testimony.
Thank you. Are there any questions? All right, seeing none, thank you very much. Up next is Emma Savini to speak in opposition to the bill. She does have written testimony representing New Futures.
Good afternoon, Chairperson and honorable members of the committee. My name is Emma Savini. I am the Children's Behavioral Health Policy Coordinator at New Futures. New Futures is a nonpartisan, nonprofit organization that advocates, educates, and collaborates to improve the health and wellness of all Granite Staters. New Futures strongly opposes House Bill 1651 because it creates a disincentive for parents to seek medically necessary and potentially life-saving treatment for their children and youth by labeling that treatment as abuse. Gender reassignment therapy is not child abuse, and this bill would have far-reaching and devastating consequences to all New Hampshire children and families. To understand the far-reaching implications, it's important to distinguish between the terms sex and gender. Sex is typically referred to as a combination of physical characteristics, typical of males or females. On the other hand, gender identity refers to a person's internal sense of being male, female, or for some people, a blend of both or neither. Further still, gender expression is how people choose to express their gender to others, such as clothing, haircuts, and other activities and roles they may choose. Some children show a great deal of distress when they are forced to conform to the gender roles that they are assigned based on their sex at birth. Some children may even experience a condition known as gender dysphoria, which other speakers have spoke on today. I won't go into it again. The American Academy of Pediatrics strongly endorses the use of gender-affirming care when treating children who are suffering from gender dysphoria. Depending on the child's age and the level of distress they're in, gender-affirming therapy can be a range of treatments. It can range from, talk therapy, as mentioned, or it can range all the way to gender transition. And it's important to note that before a child reaches puberty, gender transition is typically limited to just those social changes, such as using different pronouns, allowing a child to express their gender through clothing, haircuts, etc. After puberty, if a child continues to go through gender-affirming care, it's important to have early interventions in that care to reduce the negative effects that have been mentioned by NAMI. Rejecting a child's gender identity and denying them gender-affirming care leaves them at risk for an increased risk for depression, self-harm, isolation, post-traumatic stress, incarceration, homelessness, and as NAMI mentioned, suicidality. Suicidality is one of the most serious elevated health risks facing transgender people. Again, the American Academy of Pediatrics emphasizes that discouraging or shaming a child's gender identity or expression can harm a child's social, emotional health and well-being and may have lifelong consequences. Early intervention and treatment can combat those negative implications. While gender-affirming hormone therapy is what we traditionally think of as gender-affirming care, every child is unique, and treatment can vary from individual to individual. Those decisions should be left to the child, the child's parents, and the medical professionals treating that child. By adding this gender-affirming treatment to child abuse, you're removing that parent's ability, that child's ability, and the medical team's ability to make decisions that could have lifelong implications on that child's life. Failing to support medically necessary treatment for transgender youth and families could lead to more costs for the state in the long run, because the state will have to pick up the bill for children who have those lifelong consequences. We should be supporting our youth to achieve physical and mental well-being instead of creating barriers and dampening access to medically necessary treatment for a particularly vulnerable population. For those reasons, New Futures strongly urges the committee to vote House Bill 1651 ITL. I'm happy to take any questions.
Thank you. Are there any questions? All right, seeing none, thank you very much.
Thank you.
Up next is Jennifer Smith to speak in opposition to the bill for 3 minutes.
Hello. Thank you for taking my testimony. Maybe I'll be shorter than 3 minutes given all the other testimony. I have sent you an email this morning with a brief testimony, but I just wanted to kind of rebut some stuff, make things clear. I am transgender. I know lots of parents of transgender children. Nobody is rushing anybody into anything. I also know gender therapists. So the idea that was put out there that there's going to be lots of regrets. There's only one good study about regrets. It's from the European Union, where a lot of gender reassignment has occurred. And they found in a very large sample 4% with regrets. Those regrets were not because they weren't transgender, it was because they couldn't find social acceptance. It's rather difficult sometimes. I was pretty fortunate that even though I struggled with it, there were some other aspects of my life that made it easier. And in the 1950s and 60s, it was all called transsexual, and I knew I wasn't that because I'm attracted to women. So, you know, it's kind of... And I'm also very athletic and very competitive, and those things were things that you weren't supposed to be if you were a girl. So even though I felt from earliest times that I can remember desire to dress in girls' clothes, to play with the girls, I got schooled into being different, and I succeeded because of those other things. I have relatives who have transgender children. The thought that they're allowing a child to keep up with peers in high school by going on hormone therapy would be class child abuse, even though this was something that was approved by medical doctors and therapists after careful, yes, talk therapy, making sure that this was not some strange thing for a psychotic young person. Those things do happen. I happen to have practiced at New Hampshire Hospital as a part-time physician part of my career. There are some psychotic individuals who for some reason get a fixed delusion around gender that doesn't seem to have the usual aspects of gender dysphoria, but that's unusual, both among mentally ill people and among the rest of the population who have gender dysphoria. And I know a lot of people with gender dysphoria at this point. So I think, you know, the issue of, well, it never got voted on last year, so I guess they're treating it like it had been tabled, and you're allowed to bring back a tabled bill in the second year of the biennium. That's all I could figure. It didn't get voted on. There were a number of bills at the end of the session that never got brought to the floor. So right. I do hope that you will repeat last year and put it on the consent calendar, ITL, and that we will be done with the nonsense again till the next session, and maybe this particular rep, who doesn't seem to have anyone else who wants to bring the bill with him, won't even be here. Who knows? So please, ITL this bill.
Are there any questions? All right, seeing none, thanks so much. Up next is Anna McPherson to speak in opposition to the bill.
Okay. My name is Anna McPherson. However, that is my legal name. At school and a lot of my other clubs, I go by Andrew. I am a transgender citizen here of New Hampshire. I currently attend Londonderry High School, but I'm here instead to oppose this bill because when I heard of this bill, I had to leave my class to cry, because if this bill got passed, I would not be able to have surgery that would make my life way more fulfilling as a transgender individual. As of for detransitioners, a lot of people have come up to me and a lot of people have questioned me about detransitioners, and according to a study of 28,000 people surveyed who were transgender, 8% of them had detransitioned at some point, but 62% of the 8% had only temporarily detransitioned, and a lot of that happens before sex reassignment surgery. So like more social transitioning, where then they can go back to being on track to getting their body as their mind, their body corresponding to their mind. I'm just, yeah.
You're doing a great job.
Thank
Don't
you.
be nervous.
This is the first time I've ever done this, so.
You're doing great.
Transgender people, both on the binary and gender non-conforming, face a higher risk of suicide and self-harm. I should know. I have self-harmed. I have a lot of friends who are both LGBT and homosexual and transgender. A lot of them, they're the reason I was able to socially transition in a lot of aspects of my life. They were the reason I was able to come out to my parents. My dad is here with me today, also in opposition to the bill, and I'm super thankful for that. And to say that he could get arrested because it would be illegal for me to get drugs that would make my body match my mind is absolutely ridiculous. And if we're worried about what drugs we're injecting into children, I shouldn't be able to take my anxiety medications. I shouldn't be able to take Tylenol or any other drugs because it's going into my body and it's going to create a chemical imbalance. The anxiety medication helps me live my life, and if starting testosterone, which is what trans men and trans boys go on to make their voice deeper and change their body a little, is going to make my life more fulfilling, it needs to be legal. Thank you.
Okay, are there any questions for Andrew? All right, seeing none, thank you. And up next is Dave McPherson to speak in opposition to the bill, and he's asked for 2 minutes.
Thank you very much. I probably will not take the full 2 minutes, but my name is Dave McPherson. I am Andrew's father. The thought that sexual reassignment surgery can be considered abuse, to me, is, I don't even know there's a word to describe it. To me, personally, I don't know that there's a bigger sign of love that a parent can give to their child than to have an educated decision with medical professionals of, this is the right course that we need to take for you. It's not abuse, it's love. And I'm just going to leave it at that. Thank you.
Are there any questions? All right, seeing none, thanks so much. All right, so I'm going to close the public hearing on House Bill 1651, and then I'll open exec session on House Bill 1561 as soon as the clerk's ready. All right, so this will be the executive session on House Bill 1651. Representative DeSimone, do you have a motion?
Thank you, Madam Chair. I do. I move inexpedient to legislate on House Bill 1561 FN.
1620.
I'm sorry,
1651.
1651.
1651.
1651 FN. And yes, I'll speak to my motion.
And that's seconded by Representative Long. So I would just like to say that I don't believe it's the state's prerogative to get involved in this. This is a decision made between a parent, a child, a doctor, and a mental health professional. And we should not be making life more difficult for families who are already going through a difficult time in their lives trying to find out where they belong in this crazy world. So that's all I have to say. Representative Levesque.
I also wanted to comment on that, you know, like they said, that community is suffering so much, so why make it harder for them? They need all the help that they can get, and the legislator is here to help them.
Is there any further discussion? All right,
Madam
seeing,
Chair.
oh, Representative DeSimone.
I want to just back up what the chair and Representative Levesque said. I don't understand it, but if I was a parent, just like Mr. McPherson, I'd make myself understand it for the best interest of my child, and I'm not going to be the legislator that makes you against a criminal. I'm not. I'm just not. It's not right. Thank you.
All right. Is there anyone else? All right, I'll have the clerk call the roll.
Representative DeSimone.
Yes.
Representative Yokella. Not here at the moment, I apologize. Representative Nelson.
Yes.
Representative Long.
Yes.
Representative Alicea. Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino. That's me. I vote yes. Madam Chair Rice.
Yes.
Motion carries.
Without objection, place it on the consent calendar. And that's a wrap for today. So everybody have a great day.